Starting to get really interested with U.S. immigration. Can Donald Trump give you a green? Hey guys, before you file for your spouse, all right, friends, good afternoon. I'm Latoya McBean Pompey. We're going to be talking about some bad news that we received today out of the U.S. Supreme Court. Come on in. Type in freedom now. The bad news out of the Supreme Court ends lawful status for 500,000 or a little more than 500,000 people today. I'm going to break it down for you, and this has to do with the CHNV parole program that the Supreme Court has said that the Trump administration may proceed with. Come on in, say hello. Hey there, Rosie. Good to see you. Type in freedom now. Freedom now, freedom now, and where you're joining from. All right, guys, we're going to just jump right into it, okay? Today, the U.S. Supreme Court, through a decision, and I'll just pull it up here. If you're joining on Instagram, TikTok, those two in particular, if you'd like to see anything that I'm going to be pulling up, you can jump over to YouTube at McBean Immigration TV, where you will see what I'm going to be sharing with the audience there, okay? Freedom now, I'm waiting for, okay, YouTube is good, TikTok is good, Instagram is good. Okay, perfect. Friends, today the Supreme Court, in a decision that is very short decision, they basically said the Trump administration can, in fact, move forward with ending the CHNV parole program that allowed 530,000 individuals to enter the United States during the Biden years. And these are individuals from Cuba, Nicaragua, Haiti, and Venezuela. All right. Towards the end, after I go through the decision and what it actually means, I'll talk with you about what your next steps should be or your options are in light of today's Supreme Court decision. Just so you guys know, back in March, the government had published a notice, a federal register notice indicating that they're ending this parole. Well, they had ended it back in January. On day one, they came in and they ended various parole programs. But in March, they issued a notice indicating that they're actually going to pursue expedited removal, fast track deportation of individuals who entered through this parole program who do not leave the United States by a certain date. And litigation immediately was started, and a judge in Massachusetts paused this process to revoke the parole status of these individuals. Well, today the Supreme Court says that they're going to lift that pause and allow the litigation to proceed, and also allow the Trump administration to revoke the status. And friends, this is an immediate thing, meaning that this is effective today, okay? So these individuals have lost their status effective today, because in the March notice, friends, had given them a date of April. Let's go back over here. I have two mouses that I'm here working with today. Had given them a date of April 24th, okay, by which individuals must depart the United States by April 24th. And that was again paused, and now everything is back on, okay? So here's what you need to think about. You need to think about the fact that if you have a pending application, before USCIS for maybe you have an I-130, a family petition, or an adjustment of status application, or TPS, or asylum application, you can continue to move forward with those processes. okay, or whatever the process is, you can continue to move forward with those process. And as a matter of fact, yesterday I told you on YouTube that we received great news on Wednesday that the pause on all of those applications have been lifted, and USCIS must continue now to make a determination or a decision on your applications. Double tap the screen on TikTok so that this live session can be shared with many others on TikTok. Let's do this. I'm going to show you guys that here's what it looks like. New York Times did a terrific job showing us the numbers. 210,000 Haitians benefited from CHNV parole, 120,000 Venezuelans, 110,000 Cubans, and 90,000 Nicaraguans. Okay, and that's what 530,000 people who benefited from this. However, some of these individuals were eligible to move on with TPS. We know that TPS for Venezuela and Haiti is ending, pending litigation, of course, but they're ending, and also based on decisions, a recent decision from the U.S. Supreme Court regarding Venezuela, it's ending. We know that some individuals are also eligible for asylum, and they have applied for asylum, and some individuals are eligible to adjust their status and get a green card, and they're in process for that, okay? But a vast majority of individuals do not have any options. And so these individuals are the ones who are most vulnerable today. Okay, so this is really bad news. If you have TPS, you're not required to leave the United States with your TPS status. If you have TPS status, if you've already adjusted your status, you're not required to leave. If you have a pending asylum application, you're not required to leave. If there's another basis for you to get relief, such as a U visa for crime victims or a T visa for those who are eligible as victims of labor trafficking, or VAWA, domestic violence, if you've been abused by a certain individual, you might be eligible for VAWA. Speak with a professional about any of these options to see whether you have a basis to pursue one of those options. And this is just a refresher also, friends, about the notice from March. What it said, it says that non-citizens must depart before the parole termination date or by the date in the federal notice, which was at that time April 24th. Now we're past that. It's today. Today is the day when all of the status it ends. It's revoked. The notice had also said that non-citizens should use the CBP Home app to report their departure from the United States. Then it also say that non-citizens who have since obtained a lawful immigration status, like TPS, or other basis that permits them to remain in the United States, are not required to depart the United States pursuant to this notice. Okay, so if you're on track for a green card right now through a spouse, you do not have to depart from the United States. Expedited or fast track removal, guys, we've talked a lot about it. I have a separate video on that subject called fast track deportations. Watch that video to get some understanding about what it is. But essentially, this administration has said that they will initiate this expedited fast track deportation of individuals who have been in the United States for less than 2 years. If you cannot prove that you have been here continuously for the last 2 years, for the 2 years leading up to when this determination of your status is made, then you could be subject to this expedited fast track deportation. Now let's see, and this type of fast track expedited removal process would sidestep or just it's not a court process. Okay, it is not a court litigated lengthy process. If you find yourself in a situation where you're very concerned about whether you're going to be placed in a fast track deportation proceeding, process, you should absolutely speak with a professional about your about that and about what could potentially be done, what your options are. Okay, this is really not the time to not pay attention to what's going on, because this is a big deal for a lot of people. Okay, so guys, that's the news that came out of the U.S. Supreme Court today. I'm going to answer just a couple of questions before we go, because it is a very busy Friday afternoon for us here. Let's see. Freedom Now, thank you. 500,000 migrants of legal status stripped by the Trump administration. Supreme Court allowed it. Yeah, the Supreme Court is allowing this to proceed. When do you get the $1,000? Maureen is asking. So this is a question about self-deporting for individuals who choose to do that. From the one video that I saw of this one guy who made the decision to leave, he said that he had received it right away and some card or something like that. I have videos out there on self-deportation, specifically questions you need to ask yourself before you make the decision to leave the United States, and to make sure you're covering you understand fully what this decision involves and the ramifications, okay, of making this decision. Omar says, this is sad. This is sad because these people entered the United States through sponsorship. They had to have had a sponsor here in the United States to bring them here, to the U.S., to bring them here. And it was a legal process that was created. Some would argue that it should never have been created to begin with. But that's for the litigation process, which is still ongoing, by the way. The lower courts are still taking considering the appeal and all of that. So that process on the lower level is still going on. And while that's happening on the lower court level, the First Circuit level, the Trump administration may proceed with their plans. Okay. Okay, let's see. Let's see. I did my asylum interview on March 7th. It's still pending. Am I at risk? You are one of those individuals who have a basis, potentially a basis for remaining in the United States, and your asylum application, you're entitled to have a decision be made on that asylum application. And if the decision by USCIS is that they're not going to approve it, they're going to refer you into immigration court for a judge to take it up, well, you still have the right to allow that. You have the due process rights to see that all the way until the end, okay? And you guys have been seeing that the government now is in a coordinated effort in immigration court proceedings, looking to dismiss some cases and then arrest individuals once they walk out the door at the immigration courthouse. Watch my video, my live session on that few days ago from last week. And in that video, I provided some information and tips that you should consider if you have a hearing coming up, okay? And you're concerned that maybe they're going to be seeking dismissal of your case. Thank you, Omar. Freedom Now. Okay, so Charles says that I have, if you have a pending marriage-based green card, does that mean you can stay? I have a pending 485 and I-130. Yes, you have a basis. You are arguing to USCIS that you have a basis to remain in the United States and adjust your status through your spouse, okay, which is great. You're an immediate relative of a U.S. citizen, and that is definitely a basis to argue, okay? Let's see, Freedom Now, thank you. If you guys are just joining, I'm discussing the Supreme Court decision today, which ends lawful status for over 500,000 people who enter the United States lawfully through the CHNV parole, humanitarian parole program that President Biden had put in place. And this is effective today. And the Trump administration has said through a notice that it issued back in March that its intent is to do fast-track expedited removal of individuals who do not depart from the United States pursuant to that notice. And that's yesterday. I had also discussed with you guys on YouTube that ICE has a new quota that was given to it a few days ago of 3,000 arrests per day. Not sure where they're going to house all these people because they're at over capacity right now, but that is the new mandate at ICE. Okay, that was given to them by the White House. What about TPS? If you have applied for TPS or have TPS, you are safe for now. I don't know which country. You know, your TPS, Venezuelan TPS, it looks like that's ending, okay, based on Supreme Court decision that was issued not too long ago as well. Can I come back to the United States? Some people might be able to come back, absolutely. If you depart the United States before accruing unlawful presence, and you will face a smoother chance of returning if you have the right application petitioner, potentially an application process. Yes, some people will be able to return to the United States. Is the August 3rd expiration date of Haitian TPS no longer effective? I'm still waiting on news related to TPS, related to Haiti. For as it stands right now, first of all, I'm looking at Venezuela as an example of what could potentially happen to Haiti. It doesn't look good right now. I hope that things will make a turn, but it really doesn't look that great right now. I saw lawyers at the courthouse. They were shocked at the unprecedented immediate arrest and deportation of clients stepping out of the courthouse. Yes, this is really a bad time to, you know, uncertain time that we're all living in right now. So, you know, we're doing the best that we can day by day. Okay. Let's see. Double tap the screen on TikTok. Thank you. I'm going to be jumping off momentarily. If you have any further questions about the Supreme Court decision, as I've said, I mentioned that expedited removal is their intention. And if you have other applications in file, if you have a U visa in file, if you have a T visa in file, in process, I should say, if you have TPS in process, if you have asylum in process, if you have a marriage-based green card in process, then you have a basis to remain in the United States and have a decision be made on your application. And just Wednesday, a couple of days ago, the court in Massachusetts, the same court, the same judge that's connected to this this matter, has lifted the pause that USCIS had on all of these applications for you guys, those who entered on during the through one of these Biden parole programs. Okay, humanitarian parole program. Let's see. Okay. Let's see. As long as the marriage is of good faith, of course, that's what the government is looking for. It has always been the standard of good faith marriage. Let's see. My cousin has TPS, and his sister filed a petition for him 14 years ago. Is he at risk? With the TPS, no, not at risk for expedited removal with the TPS. Okay, let's see. I want to apply for EB3 for unskilled job. I need your advice. You could always get a consultation if you would like to discuss that further. But do some research first on what the qualifications are for that process before you book an appointment with us. Let's see. Someone says that still have a pendant I-130 case. If you take the Trump $1,000, if you take the Trump $1,000 money and do self-deportation using the CBP Home app, what will happen? I'm out of status, 3 or 5 year, 10-year ban. That's it. Okay, so if you have an I-130 in process and you have unlawful presence on your record here in the United States and you depart from the US, you will be banned. Most people will be banned for 10 years. And your case, your I-130 can still be approved, of course, by USCIS. Your case will still make its way over to the Visa Center and you will get a date for your interview at the US Embassy once your priority date comes up. The question at the time will be, well, are you trying to enter the United States before your 10 years is up? If it's 10 years for you, most likely it will be. And if so, are you qualified for a waiver that will allow you to enter the United States before your 10-year ban is up? That's the real question that will need to be considered. Freedom Now, guys. Thank you, Freedom Now. Consultation fees begin for us at $250, $300 for me. Thank you. Thank you. Go down. Okay. See if there are a few more questions. I have some things I've got to approve by deadline. So I know I'm making some people on my team a little nervous now, so I'm gonna jump off. TPS for Cameroonians. That's also coming to an end, unfortunately. What about those with pending adjustment of status for their parents? So if there's an immediate relative filing that you have for a parent who entered the United States through the CHNV process, that adjustment of status application will be processed all the way until the end now. They've lifted the pause on those applications. And so hopefully your parent will obtain the green card. It's easier, when it's easier, guys, if it's an immediate relative filing, of course, because even after this parole status is revoked today, and individuals begin to go out of status, immediate relatives will not be hurt by that, okay? Will not be hurt by that. Friends, I'm sorry to have been the one to share this bad news with you. I hope you found the information helpful. Again, if you have a pending application, like Asylum, I-130, I-45, TPS, U-Visa, T-Visa, VAWA, those applications, you have a right to allow those applications go all the way until the end and not be subject to the expedited removal. If you have TPS, you're not required to leave the United States. If you have these pending applications before USCIS, you're not required to leave the United States. If you have a good basis, obviously, to apply for those. And the federal notice that the government issued in March says that individuals must depart the United States once the parole has terminated. And if they do not, they are subject to expedited removal, particularly for those who have been, those specifically, not particularly, specifically for those who have been in the U.S. for less than 2 years. Friends, I'm sorry. Thank you so much for being with me today, and hopefully I will see you on a better note. I will be live again on Monday on McBean Immigration TV and Facebook at 1:00 p.m. Eastern Time. So join me on Monday for our next Q&A session. Have a terrific weekend, guys, and I will see you in the next one. Bye-bye.